Welcome to the Supreme Court of the United Kingdom. This is the third day of the hearing of the appeal in the proceedings brought by the Financial Conduct Authority against a number of insurance companies in order to decide what liabilities, if any, they may be under to businesses who took out business interruption insurance policies and suffered business interruption as a result of the COVID pandemic. Today, we'll be continuing to hear the submissions on behalf of the Financial Conduct Authority. So I'll turn now to their counsel, Mr. Colin Edelman, Queen's Counsel. Mr. Edelman.
I'm grateful. Postscripts from yesterday. Firstly, the defence cost cases. We've now added Travellers and XYZ to the bundle. That you'll find that in a new bundle K at page 1. And there's a short passage at paragraph 13 in the judgment of my Lord Briggs. I should, of course, have remembered that case because I was in it. That was a particular case about insured and uninsured claims. Yes. And the Zurich and IGL was in the bundle. It's bundle E, tab 21, page 473. But the relevant passages are paragraphs 36 to 38, Lord Mance, and 176 to 177, Lord Sumption. I don't need to take you to them, but just to make it clear, the only reason I raised that point was in answer to Mr. Keeley's submission that the but-for test is essential in ascertaining whether the insured has suffered loss by reason of the insured contingency. And he said it is to prevent indemnity if it is the effect of his submissions was that the but-for test is to prevent indemnity if the insured would have suffered the same loss anyway. And I was just using the defence cost example as an illustration of a situation where that is not the case. The other postscript is, and this was entirely my fault yesterday, that the other was probably as well. I meant to take you to the Court of Appeal in Silversea, a very short passage, and I forgot to do so. And it's bundle E, tab 19, page 443. And it's paragraph 104. And just to set the scene, the issue in the Court of Appeal was narrower than at first instance, and it turned on an exception on this ground. In particular, having Justice Tomlinson having said there were concurrent causes, the insurers tried to rely on an exclusion to say that the terrorist attack was the subject of an exclusion. That might explain the way it's expressed in 104. But in the second half, the court says the underlying causes of the warnings are not excluded perils. It's simply that they're not covered under A2 as perils in themselves. Something extra is required. However, they are an insured event for the purposes of the contract as a whole. There is no intention under this policy to exclude loss directly caused by a warning concerning terrorist attacks, just because it can also be said that the loss was also directly and concurrently caused by the underlying terrorist activities in themselves. And our submission is that insurers' but-for causation case is wholly inconsistent with that passage and that outcome. They've not attempted to rationalise their case with it, despite our analysis in our case, and we say that it remains the closest equivalent to our composite perils case, and if insurers are right, then the decision in Silversea must be wrong. But it isn't. So can I return now to the topic I was dealing with when we adjourned yesterday, and that was the character of the disease risk, and I'd already dealt with the nature of, general nature of the notifiable disease risk. And one then also has to bear in mind that the existing list at the time these policies were entered into did include SARS, which had emerged in the early 2000s, a coronavirus for which there was no known vaccine. And of course, it would include some new disease, viral or bacterial, for which there was no vaccine or effective treatment that might emerge after its inception. The policies could have, but did not restrict the ambit of their application to a specified list of diseases. And some insurers did do that. One of the reasons we lost on ecclesiastical was that there was an exclusion which limited disease cover to a specified list of diseases. But these insurers chose to take the plunge and offer insurance against whatever disease might show up and be added to the list. In particular, one capable of causing an epidemic, because that is what notifiable diseases are all about, and the history of humanity has been littered with catastrophic epidemics. The third feature is, and this is recorded in the judgment, there is no predictability or regularity about the way in which a disease, such as those contemplated by the notification requirement, might emerge and spread. One is necessarily talking about diseases potentially with the capacity to spread as an epidemic, and they would do so unpredictably and irregularly. In particular, they don't spread in neat circles. There would be no obvious reason for a disease capable of causing an epidemic to be confined to a particular neat circle. Fourthly, there were recent examples of extreme reactions to outbreaks of a new form of virus. I don't need to go to the page, but you'll see at Bundle D, tab 11, page 1543, there is reference that during the SARS epidemic, all sites of public entertainment in Beijing were closed for 6 weeks. That was 3,500 establishments. And also on that page, you'll see these are agreed facts, so part of the evidence before the court. 2009, there was a swine flu outbreak in Mexico. Initially, they shut down schools, museums, and so on, and that was followed by a 5-day national lockdown. So, yes, unprecedented in the UK, but there were precedents elsewhere, and the statutory powers were there to do the same thing in this country. The Parliament didn't have to rush in new statutory powers. As I showed you yesterday, they were already there. And the third feature, that was character of the disease risk. The third element is that because of the nature of the risk, if the authorities did react to a disease outbreak, they would be reacting to the outbreak as a whole. And that is an important factor that must have been appreciated by the parties, that is what would happen. So even if the outbreak included localities within a particular radius of the insured premises, the pattern of the outbreak would be unpredictable and fluid, and that meant that if there were instances of the disease within 25 miles or 1 mile of the premises, there would, in all likelihood, also be instances of the disease outside that radius, even if the disease was only local or regional. And perhaps it might be helpful at this stage, just to illustrate this point, to go back to have a look at the map in our appeal case at B10, tab 10, page 386. And you should have there the map of a 1 mile radius from the Royal Courts of Justice. And going to the north of the circle, if there was an outbreak of disease for which there were cases in Clerkenwell, to the north, it would be likely also for there to be cases in Pentonville. And going to the next page, if we go to the west-northwest of the circle, and you'll see Amersham is intersected by the radius of the circle. If there was an outbreak in Chesham within 25 miles of the Royal Courts of Justice, it would be likely to affect both East Chesham within the radius and West Chesham outside it. One doesn't need to have any great foresight to understand that. But perhaps more to the point, someone with, let's say, a restaurant opposite the Royal Courts of Justice, whose business is closed down because of an outbreak of a disease, either in Clerkenwell or in Chesham, 1 mile or 25 miles away from the premises, is only going to be affected because either there is a serious outbreak, either numerous cases scattered around both inside and outside the policy area, or because, albeit there may be some scattered cases around that 25-mile radius, any of these cases represent a serious threat to public health. This demonstrates, as the court held, that these policies, even the 1 mile radius ones, are contemplating the disease affecting a wide area, either because of the spread of the disease or because of the threat to health that the scattering of cases, if it's in its early stages, might represent. That all brings one to the fundamental question when considering how to construe the language of the policies as to whether the intention was or could realistically have been to confine indemnity under the policies to situations where the cases within the relevant policy area alone, that is, taking them in isolation from all other parts of the outbreak, were the sole proximate cause of the interruption or interference. And that is effectively, either through construction or through their but-for analysis, is where insurers with the disease clauses want to take you. That would necessarily exclude indemnity for any disease outbreak other than one confined exclusively to the relevant policy area, and that, the court, we submit, rightly concluded, is inconsistent with the nature of the risk that is being insured. The way in which the insurance provisions are expressed, however, is wholly consistent with their having been intended to operate consistently with the nature of the risk. And when after all these introductory remarks, I come to the individual wordings, I'll seek to... Yes.
Haven't you slightly overstated the position, Mr. Edelman? It's not necessary to insurers' cases that all the incidents of the disease are within the radius. They say that the cases within the radius must be sufficient to bring about the result, in effect.
So that is...
So they could contemplate a few cases, they could contemplate some cases outside.
De minimis, yes. They could contemplate de minimis cases, but that is unrealistic when you're even assuming 1 mile away, or the more so 25 miles away, that you are assuming something remote from the premises, not directly affecting the premises, something remote from the premises, which is a disease outbreak, and it is, we submit, inconsistent with the nature of the risk for it to be proceeding on the premise that there will only be de minimis instances of the disease outside, because that's not consistent with what they're insuring. And we submit there's some particular features, is that the further element, fourth element, particular features of the policy which are consistent with a recognition of the nature of the risk that they are insuring. One thing perhaps you may or may not have noticed, but is noticeable when you were being taken through the policy terms by Insurers Council, is that they don't even require any particular case in the radius to have been the subject of a notification under the regulations, or even to have been the subject of diagnosis. Now, if they had wanted the cases in the policy area to be the real cause of the interruption, or the government action, I should say, then one might have expected that they would specify that. But they, as I said, they don't require notification or even diagnosis, and some don't even require cases of the disease to be symptomatic. And for those that do, symptomatic is enough. So the fact that someone in the relevant policy area has lost sense of smell and taste is sufficient, whether or not they've gone to a doctor and the doctor has diagnosed it and the doctor has notified. Another feature you'll notice is that none of the policies contain any qualification as to the tier of authority that reacts to the disease outbreak. For example, they don't specify that it has to be local and thereby encompassing regional or national. They leave the matter entirely open. All these features are consistent, and we say only consistent, with the policies operating in harmony with the nature of the risk that was being insured, and with the court's conclusion that all these policies are focusing on is the mere presence of the disease within the policy area. Because if more was required, the policies could have said so in either of the respects that I've specified, either action of a local authority only, or requiring that there have been, that the relevant cases are those that have been notified to the local authority. And so we come to the next feature, which is whether there is a commercial purpose to the relevant policy area. And this was a matter on which I was taxed by Lord Justice Flo in the initial stage of the case, where he initially perceived our submissions as undermining the purpose of the radius. But as you've seen, the court was persuaded that there is a very real commercial purpose to the radius, and it again is one which is consistent with the nature of the risk, because it's there to ensure that for there to be cover, the area surrounding the insured must have been caught up in the outbreak and not merely impacted by reaction to some remote outbreak. And of course, as this case has demonstrated, when you have a serious outbreak, the government will act nationally. And places like the Scilly Isles did get caught up in it, even though they had no cases, because of the need, not just the need to prevent spread, where it is, but also where it isn't yet. And you're trying to prevent the places where it isn't yet from being affected by it. And in that regard, the insurers have some protection from the disease risk. Yes, ma'am.
What's the point then of having any radius? If the silly owls are caught up in it, even though they've got no cases, the radius might shut them out. It's a useless qualification on your argument.
No, because there's no insurance cover in the silly owls.
So you say that they are shut out?
Yes, yes.
Yeah.
Sorry, I may have misspoken, but what I meant was that the silly owls get caught up in the lockdown, even though there are no cases within a 25-mile radius of the Scilly Isles, and therefore insurers don't pay.
Right.
So I was describing the nature of the disease risk that, my lords, remember my 25-mile circles. There are some of those circles which are more loosely populated than others, and some which are more densely populated. And one can imagine that there may well be one circle which is not affected by the disease, and but the rest of the country is the government still acts nationally. This is, in fact, and what I'm doing now is turning insurers' but-for case against them to demonstrate the purpose of the 25-mile circles, because they say, well, Mr. Edelman's map of these 25-mile circles, accepting its artificiality at the moment, demonstrates that if there had been no disease in one of those circles, the government probably would still have acted as it did. And I said, well, I say that demonstrates the protection insurers have, because people in that 25-mile radius circle have no insurance cover. And the benefit to insurers, of course, is that the smaller the area, the greater the prospect of there being no cases of the disease within it. If you have a 25-mile area, you have a much greater chance of the disease being within that 2,000-mile square area. But if you only have a 1-mile limit, you've only got 3 square miles to play with. Unless, of course, the only time it doesn't make a difference is when you have a really, really severe epidemic, such as we have had and still have in this case. Only then does the policy area cease to be a relevant protection to insurers. But that's rather like saying that an insurer who insured various properties around the southeast who never expected there to be an accumulation risk, saying, well, I never intended to insure the October 1987 storm, because that was an unprecedented storm which gave rise to an accumulation risk for insurers insuring properties in the southeast of England, which they never would have contemplated. But that's insurance for you. Sometimes bad things happen. And that's just exactly what's happened here. They've insured the disease risk, perhaps on the basis that everybody assumed that it would be rather like it was before. But along comes the disease equivalent of the October 1987 storms. And I'm afraid that's the risk that insurers take. And what they're trying to do, we submit, is escape from the consequences of the policies they've written, because the catastrophe risk in the category of risk they have underwritten has transpired. The 6th factor is the consequences of insurers' approach. And a powerful factor we submit against the construction and causation arguments advanced by insurers, and a factor that was taken into account by the court, is the arbitrary and irrational consequences of a requirement that the interference or interruption be caused solely by cases of the disease within the policy area, subject to the de minimis perhaps exception that we were discussing a moment ago. But that is the result, one way or another, that insurers seek to achieve, and we submit that is demonstrably inconsistent with the nature of the risk being addressed by the clause. As I've already submitted, outbreaks do not occur in neat circles. Why should the response of the policy differ simply because the pattern of spread means that it is outside as well as within a policy area? If it's donut shaped instead of round shaped in its spread? Why should a policyholder on the eastern side of Leicester with a 1 mile radius policy be refused cover for the local Leicester lockdown in circumstances where there are many cases of COVID within the 3 square mile circle around his property, simply because there were also many other cases on the western side of Leicester outside that circle, and Leicester was locked down because of all the cases in Leicester? Insurers would fairly be able to say that all of Leicester would have been locked down, whether it had just been the eastern side of Leicester or the western side of Leicester that had been affected by the outbreak. But insurers' case is that if that 3 square mile area had on their hypothetical miraculously, incredibly been disease free, because all of Leicester would still have been locked down, there is no cover, as Leicester obviously would have been locked down to prevent the disease spreading from the western side to the eastern side. And one just has to look at the clauses to see whether that makes sense of the nature of the risk that's being insured, and whether one can really read that sort of result in either to the policy language or force that result onto the policy language by some but-for causation test. And then we have also the questions to why the policy should, because this is the consequence of insurers' submission, why should the policy respond differently to a disease that spreads locally, slowly, with localized lockdowns initially, as compared to one which spreads rapidly, where the lockdown imposed on each locality is imposed simultaneously by a regional or national authority? These consequences do appropriately attract the description of, in our submission, of being arbitrary and irrational. And if that is the way accurately to describe those consequences, then we say they cannot have been intended, or at the very least would require very clear words for a court to conclude that such consequences were intended. And of course, there would be the impracticality, given the nature of the disease risk, of ever proving causation by reference to cases only within the policy area in any disease outbreak case of any significance. This outbreak just serves to highlight that point, but it would arise even with a lesser outbreak unless it truly was a very small localized outbreak. But if insurers were intending to insure only the disease at the very lowest end of the spectrum, then they could and should have said so in in clear terms, and they would have set, as I submitted, different criteria for the triggering of the policy. They seem to assume in their submissions that all these factors are just a consequence of their construction, and it's a so be it, and that's the party's bargain, without addressing the point that we have made and that the court made, that the anomalous consequences of a construction make it unlikely that it was intended by the parties. And as I submitted, these anomalous consequences apply even without a pandemic, but just a more localized outbreak, because the cover depends on the lottery of how many cases are outside the policy area in addition to those inside the policy area.
Mr. Edelman?
Yes.
If you're right on concurrent causation and there's no but-for requirement,
Yes.
do many of these points really affect construction?
No, they don't. If I'm right on concurrent causation, if the but-for point doesn't arise, then this doesn't matter.
Right.
This is really supporting the court's approach to construction, which is that the disease, which avoids the causation argument, which is essentially that what these policy requirements are about is the fact that the outbreak must have a presence in the policy area. In other words, the policy area must be affected not just by what the government has done or the public authority has done, but also by the disease itself. And that's what these submissions are directed to. But my lord is right. If concurrent causation works, then that undermines insurers' entire case. But in order to support the court's construction, we just need to deal with some of the far-fetched examples that insurers have come up with in an attempt to undermine our argument. Our main point is that these are entirely divorced from the reality of the significant proportion of the population having been affected by this disease. One example is a man in a trawler who happened to stray inside 25 miles of the Scilly Isles. Well, clearly there would be an argument about whether a case of someone at sea was actually the sort of case the government was considering, even when it was considering everything in the round. Their concern would have been when the crew came ashore. The concern was the spread of the disease in the country, and that would only happen when the crew disembarked. So there would be a very real question as to whether the causation test formulated by the court, or even our alternative concurrent causation test, was actually satisfied by such a case. So these are far-fetched examples. The other one was an infected driver on a journey. And clearly, each stop that driver made would be relevant. And someone who's a carrier of the disease who stops at a motorway service station is a very clear disease spread risk, and that there may be a lockdown of the area if someone with a contagious disease has stopped somewhere. That's why the government wanted to stop people travelling, no doubt, because as they travelled, they would come into contact with people. Now, it's unnecessary for the court to decide, we submit, whether where transit is through an area without stopping in a car with the windows closed, or whether it is sufficient for the clause. And also the more far-fetched, even more far-fetched example, someone in an aeroplane flying overhead and not landing in the area, or even in the UK, is relevant. We say these are far-fetched examples and wouldn't satisfy a causation test. It's not going to arise on this pandemic because apart from the odd notorious case, an insured, the policyholder wouldn't be able to prove such a journey. And as I've submitted, they would need to show a causal link. But we say that the detachment from reality, which these examples demonstrate, is a hallmark of insurers' submissions. Now, can I move from those general points to some construction points which were dealt with in the submissions? And what I intend to do is hopefully save time rather than going through laboriously the same points in each policy. And I will come to the policies shortly. What I want to do is just deal generically with some of the sorts of points that have been taken, because we have dealt with these points in our respondents case as well. One aspect is interruption part of the insured peril? Mr. Keeley in his submissions appeared to include interruption in his definition of the peril. That's day 1 at page 128. And insurers seem to recognise that this doesn't really go anywhere because of the requirement of a causal link will turn on the language of the policy, which indicates whether the default proximate cause test has been modified by the parties. But just in case it matters, we say that on analysis, interruption and interference are an element of the peril because they are addressing an operational impact on the business. What is being insured, and you see this explicitly in a number of the policies, is loss as defined in the policy mechanisms, which must be caused by the operational impact on the business, namely interruption or interference, in turn caused by whatever is designated as the insured contingency. And this ties in with the history of the evolution of cover, we say, for consequential loss in damage cases, with the requirement that for consequential loss to be recovered, it must have been caused by interruption or interference with the business. But yes.
Is it any part of your case, Mr. Edelman, that some subtle distinctions are to be drawn between phrases like resulting from or following, or do you accept that they all should be taken to be one or another way of indicating proximate cause?
I don't accept following as proximate cause, and Hiscox agrees with us on its clause. They agree that following is a word which is not consistent with proximate cause. Other words we're prepared to accept as a result of proximate cause, but underlying all our submissions is that actually it doesn't matter because of our concurrent cause argument.
Yeah.
But I do draw the line at following, and I'll deal with the one case where that arises. When I come to that wording, I'll deal with it. But we say that is a departure from proximate cause, as Hiscox agrees. Now, some reliance is placed on surrounding clauses being focused on damage to premises or something happening at the premises. Now, as we've said in our case, that these disease clauses are still premises based because there must be an interruption or interference with the business carried on at the premises. The fact that they are contemplating something not specifically linked to the premises is inherent in the contemplation of a disease outbreak some way away from the premises, having an effect on its operations, and under these disease clauses in a way which is not specified. It can be any consequence of the disease which then has an effect on the business at the premises. One other aspect insurers refer to is clauses refer to disease at the premises, and that's relied on as part of the construction exercises trying to demonstrate a locality. We say that in the context of the cover also given for wide area disease outbreak, the natural conclusion to draw as to the intended sphere of operation of the disease at the premises element of the cover is to address specific measures taken in relation to the premises. That operates as a rational dividing line between the two elements of disease cover. They are intended to capture different aspects of the disease risk, one capturing something which may happen specifically to the premises because of something that happens at the premises, or where the premises is the source of something that happens, and the other where the disease outbreak affects the business of the premises but has nothing directly to do with the premises itself. It's caught up in the consequences of a wide area disease outbreak. And the two other topics, other territorial scope policies, clauses, which my lords had reference to. Now, the way in which those territorial scope clauses, perhaps with a radius limit, might impact depends on the nature of the peril that's being addressed, and I'll deal with that more specifically when I come to the Hiscox policy, where Mr. Gazeman made a point about that, but they don't assist in understanding how a disease peril operates. And so one needs to look at the nature of the peril that was being contemplated when the radius applies. But even those other clauses are not without the same issues. If I can ask my lords just to look briefly at a clause in the arch policy, that's C tab 5, page 317. And this is, so you understand the significance of it, this is for guest houses and bed and breakfast establishments, so holiday industry. And perhaps unsurprisingly in that context, at clause 5, there's a pollution and oil spillage clause. Pollution or oil spillage on a beach, river or waterway within a 25-mile radius. And what if the establishment loses business because, let's say, a whole stretch of coastline is closed, so people don't want to come there on holiday, because there is a spillage along a 5-mile stretch of coastline, 2.5 miles of which is inside the policy radius, and 2.5 miles is outside the policy radius. And the authority action affects the policyholder because they close the whole coast, that stretch of coastline. A length either side, obviously they would have to clean up, and they'd be worried about preventing the contamination spreading to other parts of the coastline. Is it seriously to be said that there would be no cover if the authority would have acted in the same way if the pollution had just been of the 2.5 miles outside the policy radius? Or is it sufficient that there is contamination within the policy radius, and that is part of the pollution and contamination spillage? In other words, there is presence of contamination of a beach within the 25-mile radius. So we would say, actually, this supports our case. It also operates and can only sensibly be understood as operating as a qualifying condition. Pollution or oil spillage is something which can spread unpredictably and necessarily with an oil spillage fluidly, in fluid patterns, as the court said about the disease risk. And we'd say it would be sufficient if the pollution as a whole included some part which was within the policy area. So these sorts of provisions don't actually help insurers, they only hinder them. Finally, a short point made by Mr. Gazeman about the food poisoning risk, because he said that was bound to be local. Well, I seem to remember there was something about salmonella and eggs, and that was a food poisoning risk, which was not exactly regarded as local. Can I now make some, again, these are just preliminary remarks before I turn to the policies, which I will be doing, as I said, shortly. Some preliminary remarks about hybrid and prevention of access clauses, because these involve the different point about what goes in the counterfactual. Is it all of the ingredients or only some? You'll have seen from their reaction to our pre-trigger downturn point that insurers are very keen to emphasize that the policies are not triggered until each of the ingredients of the clause is satisfied. This is Mr. Gazeman's favorite A plus B plus C plus D example. My maths wasn't very good, but I can't add up letters, but I think I can do simple addition. So it's got A causing B, which then causes C, which then causes D. And each element in the chain may have its own specified causal test rather than the default proximate cause test. But each element, and we accept this, is specified as having to be the or a cause of the next ingredient. Now, this is perhaps a novel issue for the law of insurance, because in my limited experience, one has only had to deal with what might be described as singular perils, like perils of the sea. And that the Silver Sea case was one of the few examples of a composite peril. But the Marine Insurance Act, things like perils of the sea, fire, and war risks, is addressing what might be described as singular perils, as opposed to a peril which requires a succession of causes in combination. So the only case that I'm aware of which addresses this sort of clause is Silver Sea, but the trends clause, the trends clause issue didn't arise in that case. But one cannot, in our submission, fairly or accurately describe these clauses as being anything other than, as the court described it, a composite peril. In other words, an insured peril which comprises a number of ingredients. And the reality of what insurers under these policies are still trying to do, as they did unsuccessfully below, is to cherry pick elements of that composite peril in their counterfactual world under the trends clauses, notwithstanding that each element is a required causal ingredient. And given that each element is part of the composite insured peril, we submit that it is heretical and wholly contrary to the commercial purpose of trends clauses to remove an element in the trends clauses in whole or in part. I think I've mentioned, I may have, sorry, I've just had a message that I may have said it was the art policy that I was referring to with the pollution one. It was the Argenta. If I misspoke, I apologise. It was Argenta, not art. Can I return to the point I was making? So I have messages coming through on my phone, I'm afraid. It's not like the days when you get an instant sticker, so I do apologise for this method of communication.
Oh, if you look on the bright side, nobody can tug your gown, Mr. Edelman.
Well, my lord, I wouldn't have been wearing a gown in front of my lord anyway. My suit flap may be. Lords, as I've submitted, trends clauses are there to make allowance in the quantification process for extraneous influences on the performance of a business and not to reintroduce the effect of one of the ingredients of the insured peril itself. That is, we say, inconsistent with the commercial purpose of a trends clause. And as we've sought to demonstrate, commercial purpose is not mere assertion on my part, it's what the history and reason for introduction of these clauses reveals. Now, one good indication that this cherry-picking exercise, yes.
Can you hear me, Mr. Edelman?
Yes, I can.
Can I just check I've understood your cherry-picking point in its essence before you get to the detail? I think you're saying that if you have a composite type of peril, the ABCD type, then unless you make a choice of one or other of the elements, you end up leaving all of them in the counterfactual.
Yes.
Yeah, okay.
Yes, but subject to the point. I'm sorry, my lord. I lost the audio. I think I may have overspoken.
I just want to say thank you if you were simply going to answer yes. Yes,
that's right. But that was subject, obviously, to the point we were discussing yesterday, that if you have a prevention of access clause, that doesn't lead in to non-prevention of access related losses, because what you're doing in the trends clause is you're readjusting the turnover, and you're saying, well, your business was closed, and what were the people can get to your business, what loss did you suffer from that? And then you're looking at what you take into account in the counterfactual. It's not open to insurers to say, well, the church was closed, so you and you accept because it was closed, you had no collection income. This was an example debated in below because of ecclesiastical being a party to the proceedings. But your parishioners wouldn't have come anyway because of COVID. But the contemplation that the church would be closed because of the emergency is part of the counterfactual. You take out the concurrent cause of the disease. But as we say, one good indication that this cherry-picking exercise is not how these policies should work is that the insurers running this point have changed their minds about what is to be extracted, with RSA changing their mind from their pleaded case and all their written submissions as late as Mr. Turner's submissions yesterday. And they have been and remain inconsistent and in a number of respects incomprehensible. And I'll demonstrate that to you in a moment. But if that is the situation, it's pretty good indication that that's not what could have been intended, and it can't be the correct way to go about things if no one really can say with any confidence what it is, or clarity, what it is, which elements are being subtracted. Now, just to run through where we are with the insurers on that, Hiscox have always said, in fairness to them, but there are some difficulties with what they say, that one takes out the combination, but only each element insofar as it caused the next. So they've said you always take out the inability to use the premises, that's in their clause, and they've always, I don't know if it's helpful to look at their clause while we're doing this exercise, it may be. If we go to C tab 6, page 401, it's inability due to restrictions imposed following occurrence of disease. And they've always said you take out the inability to use the premises, the first bit. Fair enough. Then they've said you take out the restrictions imposed, but they've never, until yesterday, been specific about what restrictions you take out. They say insofar as they cause the inability to use. Well, Mr. Gazeman, although he took this very swiftly, said, take the example of a nail bar, he said, you remove regulation 4 in its entirety. Well, that's a bit odd, because if you're going to one bit only insofar as it causes inability to use, would you not simply take out the nail bar restriction, leaving all of the rest of regulation 4 in? But of course, Mr. Gazeman recognises perhaps. Yes, Mr. Gazeman.
Mr. Edelman has misstated what I said. I did not say that you took out regulation 4 in its entirety. I said the exact opposite, that you take out the part which affects the nail bars.
Yeah. Well, we can check the transcript. Thank you.
Right. Well, I'm obviously, and this is part of the problem, I still misunderstood what he was saying. Found it very different. So you just take out nail bars. Okay. Now, I think we've got there finally after an 8-day trial, an exchange of reams of written submissions. I think I finally understand what Mr. Gazeman is saying now. You take out nail bars. So you leave regulation 4 as it is, but you imagine that the government, for some obscure reason, decided that they were going to exempt nail bars. Of course, he has to do that because he doesn't want to be paying nail bars, each nail bar, a windfall profit of being the only nail bar open in the country. So he has to say all nail bars are gone. So we then have to imagine this world in which the government has closed everything in regulation 4 and regulation 5. Sorry, regulation everything in regulation 4 except nail bars. But that begs the question, why, if you're removing that bit, why don't you remove all of regulation? Well, it's one regulation, it's one legislative provision. And why it's all part of one indivisible government response to the situation. So the counterfactual in this case involves not only subdividing the elements of one particular regulation, but the whole concept of taking apart one piece of indivisible statutory provision, and it then leaves.
I suppose if you wanted to really tailor it down and say insofar as, you could imagine hypothetical regulations which didn't prevent the use of all nail bars, but only some.
Yes.
And then imagine that, in fact, it's only the aspect that affects this particular nail bar that is relevant.
But it's a really, my lord, it's a question of, it just becomes the ridiculous counterfactual. And when you actually then are translating this into the application of the trends clause, and of course I accept entirely that the hypothetical that the trends clause is contemplating is just that, it's a hypothetical. It's not actually the real world, but you must be contemplating, and all the textbooks demonstrate that what you are contemplating is what would have happened in the normal real world, not what would have happened in some world that could never exist. It's totally impossible to imagine the government passing these regulations and not including nail bars, save perhaps by inadvertence. It is just an entirely impossible counterfactual. The fact that counterfactuals are hypothetical doesn't mean that one creates one which could never have existed in any possible scenario. It's just a creature of Mr. Gazeman's imagination, and it is just imagination because it's fantasy land. And how are you going to? It really is a recipe for Hiscox to be able to say, "Oh well, if it had only been nail bars shut, everything else would have been the same. Only nail bars allowed to stay open, everything else would have been the same. You'd have had no business." And of course, what he still wants in the counterfactual is Regulation 6, saying that everybody must stay at home, and which is making non-essential travel restricted and social distancing. But the even more interesting aspect of Mr. Gazeman's submissions is what he says about disease, because he says you take out disease insofar as it led to the government restrictions. And he said, as if our failure to understand it was due to a lack of intellect on our part, which I'll readily confess to. But I think on this, it's perhaps not a symptom of my lack of intellect. He says it means causatively rather than quantitatively, as though that is the key to understanding what he is saying. I'm afraid to say we still don't understand what he's saying. If he's saying causatively, then all of the disease caused the regulations to be passed, and he's admitting that all of the disease must come out, which is precisely what the court said, which makes one wonder why he's appealing. But it may be he's saying, well, you leave all of the disease in, so you assume that the disease did happen in the counterfactual, but you assume maybe that the government didn't react to it. Well, I don't understand that, because then the government, you've got the government reacting to it, but leaving nail bars open. But if you've got the disease in and everything else, nothing's going to happen anyway. So where this gets him and how it's supposed to work is just, with respect to him, and I have the greatest respect for Mr. Gazeman, is the one aspect of his submissions that is and remains utterly incomprehensible, and just shows what the difficulties are in this cherry-picking exercise. I now move on to RSA. In its written case, and indeed its defence, what it does is says that you remove the entire 25-mile circle of the disease not only insofar as it falls closure restrictions. This is the RSA1 hybrid. Perhaps we ought to have that open. The relevant clause at C, tab 15, and it's page 1129. Closure or restrictions placed on the premises as a result of a disease within a radius of 25 miles. So what he says was we took out the 25-mile circle of the disease, and their case was that, and this is their defence most clearly at paragraph 62. You don't need to look at it, I'll give you the reference. It's G, tab 19, page 162. They say that means that COVID would still have been present outside the relevant area. And that's really part of the radius point. But that was the extent of his counterfactual. He left all of the restrictions in. He didn't say anything about that. But then Mr. Gazeman obviously had a word with him when we pointed out some continuing inconsistencies in our respondent's case, because yesterday he changed his mind and said that he was wrong. Now, what he now says remains, how can I put this, rather opaque, because of course his clause is in rather a different form from Hiscox 1 to 3, which we were looking at. It has a radius, and it may be that because he didn't understand the disease insofar as he wasn't quite sure what Mr. Gazeman was saying about that, but really I assume he's now saying one only removes the restrictions insofar as they were placed on the premises. But that, if that's so, I assume if he's identifying his position with Mr. Gazeman, that must now be his case. That is not his pleaded case. It's not the case he argued below. It's not the case he set out in his appeal case, and it is entirely new. And it yet again demonstrates the difficulties that there are if one starts trying to cherry pick. Everybody picks some different cherry. And then we have Arch. And perhaps if we go to their clause, which is a prevention of access clause, and it's at tab 4, page 226. Sorry, the relevant clause is at 227. You'll see the introduction to 226, so that's where the extensions start. Sorry, the clause is at 226 under item 7. 227. Prevention of access due to actions or advice of the government due to an emergency which is likely to endanger life. Now, Arch had previously said you take out the government action and the prevention of access, but you, from the counterfactual, but you leave the disease in. And that was their defence. And you'll see that we've given the extract at G17, page 150. It's also recorded in the judgment at paragraph 447. Their appeal case, this is paragraph 48, you'll note, says the counterfactual is if the prevention of access had not occurred. Now, we pointed out in our respondent's case that this was a change of case. because previously they'd not just taken out the prevention of access, but they'd also taken out the government action. And Arch has now reverted to its pleaded case, because on day 2, this is page 80, lines 9 to 13, Mr. Lockie said, the relevant part of the regulation requiring the category of business to close its premises is assumed not to have been made. So I assume he's now aligned himself with Mr. Gazeman's particular point about there's just the, if it's a nail bar, it's just the nail bar. That's not what he pleaded. He pleaded the government action. It's not what he put in his appeal case. And there just appears to have now been an alignment with Mr. Gazeman. And it's still not clear what he actually means. Does, for a category of business, does he mean subcategory of business, going down to the particular of a nail bar, or just a category of business, category 4, category 5, category 3? So we still don't really know the answer to that question. And we'll just have to wait to see if he clarifies it yet again in his reply submissions. But the clarification doesn't matter. Again, what matters is the inconsistency and the conflict between the respective submissions that arises. And we say that of itself demonstrates the impossible task that there would be to work out on insurers' approach what the counterfactual world would look like. And can I add this, because Mr. Gazeman criticised our reference to 2,000-page expert reports, but the court needs to bear in mind that Hiscox was insistent on introducing into the, I've lost the audio for the video for Lord Hodge. I hope I've still got audio contact with my Lord Hodge, please.
You have audio contact. I've got a message saying that something's gone wrong with the video.
Well,
so we're about to have a short adjournment. I'll sort the video out during that adjournment. Not short adjournment, the 5-minute adjournment. I'll sort it out then.
Thank you. I've literally got a few sentences and then we might pause then anyway. I just wanted to make the point that Mr. Hiscox were insistent on an agreed set of agreed facts about the position in Sweden being in the agreed facts. And the purpose of that was that Mr. Gazeman's clients would want to argue, it seems, that the performance of a business without a restriction should be compared to the performance of businesses in Sweden where the government did not act. As it so happens, we believe, because of constitutional restraints on when the circumstances in which an emergency could be declared and the powers could be exercised. But be that as it may, that's what he wanted to do. And they've not resiled from that. And so we presume that they will be using statistics from Sweden and customer behaviour evidence from Sweden in their counterfactual if the disease is extracted, whatever part of the disease is extracted, or government restriction other than the particular nail bar restriction is extracted from the counterfactual. Hence our concern at 2,000 pages of expert evidence. And my lord saw the passage in Silversea, the sort of evidence that insurers tried to adduce in that case about consumer behaviour. And that is what these unrealistic counterfactuals may well lead to. My lord, that was a natural break in my submissions. I'm about now to turn, at long last, perhaps you might say, to the wordings themselves, and therefore it might be an appropriate moment to take a 5-minute Great.
Thank you very much, Mr. Edelman. We'll adjourn now then for 5 minutes. I think we're ready now to resume. Mr. Edelman.
Well, on Mr. Gazeman's intervention, I revisited transcript yesterday, pages 67 to 68, and I maintain my stance that it is entirely unclear that what he was saying was nail bar only, and I would invite my lords to revisit that part of the transcript to see what Mr. Gazeman said, not to pick him up on this. You know, he's entitled to clarify what his submissions meant, but on how shifting this sand actually is. Now, Lord, going to QBE, which is the first insurer I want to deal with because they came up first, their first policy, QBE1, Bundle C, tab 12, page 745. Now, if I can be excused one purely forensic point, at trial, QBE came 7th on the list of 8. Mr. Crane, poor Mr. Crane, was promoted to number 1, no doubt because his clients had success on QBE 2 and 3, and insurers wanted some success on that. But anyway, he was sent over the top first. I hope it will be to the slaughter, but that is in my lord's hands. Let's start with this policy, and what I'm going to do is make some submissions which will be hopefully also referable to some of the other policies and save some time. So if we look at the introductory words, interruption of or interference with the business, you'll just see, looking at the surrounding clauses on this page, they are all prefaced with the words loss resulting from. And if you go to the previous page, page 30, you'll see the same pattern. So just as a small point, but it reinforces the point I was making, all of the other extensions are prefaced with the words loss resulting from, and it looks as though those words are an accidental omission from this extension because it's the only one which doesn't have those words, and there's no obvious reason why it doesn't. So those words are to be read in, but nothing turns on it save for that small interruption herald point that I mentioned. So it's that if we read this clause, it says interruption or interference with the business arising from any human infectious or human contagious disease. And one can read the clause as quite readily as applying primarily to those words.
And it has to be a notifiable disease.
Yes. And then it sets the criteria. This is my point. It's any disease, and then it sets what we say are 2 qualifying criteria, which is wholly consistent with the construction that the court has adopted. The first thing is it tells you what sort of disease, adjectively, what sort of disease it means when it says human infectious or contagious disease. It excludes AIDS, and it says an outbreak of which local authority has stipulated to be notified. So then that's where you get the qualification that it should be notifiable. And then the next, and we say the court is quite right, it's an adjectival qualification manifested by any person whilst in the premises or within a 25-mile radius. Manifested means diagnosed or symptomatic. We say, and it's a simple point, but the court accepted it, and we say rightly so, that it This is just saying that you're covered for any human infectious or contagious disease, provided that that disease has manifested itself in your policy area, which it has. And that's all the policy is saying. And now I hope my lords will see the point. It doesn't require the policy within the area to have been notified to the authorities. It doesn't require it to have been diagnosed. It could be diagnosed, but it may not be. If it's diagnosed, then obviously the doctor would have a duty to report, to notify it. If the doctor's under the regulations, a doctor has an obligation to notify, and there's also requirement on a testing laboratory. Some important points to note. QBE did think about the exclusion of a disease and chose only to exclude AIDS. So they could have limited the scope of this to a list of diseases or to diseases on the notifiable list as at inception, but they chose not to do so. I've made the duty to, there's no reference to a duty to notify point. I've made that point. And the requirement for manifestation, simply someone displaying symptoms. And the final point, although it says that interruption or interference must arise from any human infectious or human contagious disease, it's self-evident that the within 25-mile radius point is not going to, of itself, interrupt or interfere with the business. A disease incident is not directly going to interrupt or interfere with the business. Something more has to happen. And this is obviously contemplating, because of the nature of the disease and the reference to something which has to be notified if there is an outbreak, that the public authorities will be acting. And they will be acting to the whole of the outbreak. That's part of what the court below assumed, that this is presuming the government's reacting to something. They're reacting to an outbreak of a disease, and all this, and this clause is saying, well, we'll insure you for interruption and interference arising from the disease and outbreak of which has to be notified, as long as someone in the policy area has manifested the disease, has symptoms of it. And so we submit that on this policy, you really don't have to resort to concurrent cause. It is ensuring the disease on the proviso that someone within the area has got it. And it's saying nothing about, and deliberately saying nothing about the causative impact of the person or people in the area who happen to have manifested the diseases, who happen to have symptoms of it. And if you're covering someone who is merely symptomatic, who hasn't even been diagnosed, that's obvious. That must obviously be the case. And should say that QBE is accepted, and I'd be unfair not to make this point. They accept that what this clause is contemplating is an outbreak of the notifiable disease and the reaction of the authorities to it. And that's their case at paragraph 17 and 18. So we say
Sorry, before you move on, Mr.
Yes,
Edelman,
sorry, my lord, I just looked down.
it surely doesn't have to involve a reaction of the authorities. It would be enough, wouldn't it, if the fact that somebody at the premises who got a disease caused people to stay away, for example.
Yes. Yes.
And not to go and buy things there, or they had to shut the shop as a result. I mean, it doesn't require authority intervention, this clause.
And this also applies to public reaction, of course. So
Exactly.
even if there's no government action and people themselves become nervous, they hear that there's an outbreak of the disease or a disease in this area, and people stay away from the area, or they stop mixing voluntarily. That is all covered, and all that's required for the policy trigger is that someone in the area has symptoms of, and there's no possible tenable construction we submit on this particular clause to say that the manifestation within the area must itself be causative as opposed to a qualifying condition.
Well, it's certainly a tenable construction. It just reads the whole clause as definitive of what was caused the interruption.
Well, if it would be a disease, the problem is it's manifested by any person. It's just manifested by any person within the disease, within the radius. That's the problem with this language. As long as it's manifested by someone, there's no suggestion in the language that the manifestation of the disease has to be what is causative. That's my point.
Well, it depends how you read the clause, but one reading of it, it's the whole description that has to be causative.
Well, it's right. Well, one could debate it, but we submit that if insurers wanted to make the manifestation within the area part of something, part of the causal requirement, that manifestation has to be causal, then much clearer language would be required. But certainly, the construction that the court placed on it is certainly, I would say, at the very least, a natural reading of the clause. You don't need to force anything onto it or read words into it. It is a natural reading of the clause, and it, compared to what the insurers could have done, requiring the individual case to have been a case which was notified to the authorities, it is the most appropriate reading. But this might be a useful vehicle anyway for then testing the alternative argument. What if QBE is right and somehow this policy is to be construed as only addressing or contemplating cases of the disease inside the radius in some causative sense? What is the relevance of the outbreak also being outside the radius? Because, of course, it will be the fact that the outbreak inside and outside is still part of a national outbreak. And of course, that's the fact that it is part of a national outbreak is relied on by QBE and the other insurers. Our primary answer remains one of construction. Even if it is addressing or contemplating cases within the policy radius, it does not require the outbreak to be only within the relevant policy area, the point court made, so as to create the equivalent of an exclusion clause in the provision in respect of the causal effect of the outbreak outside the relevant policy area. And Mr. Crane explicitly accepted that in his oral submissions. This then leads to two alternative analyses. It further supports the conclusion that of the court that if the local outbreak is an indivisible part of a national outbreak, it cannot have been intended that the indemnity should proceed on the basis of treating the outbreak outside the relevant policy area as somehow a competing cause of the interruption or interference. The other way is to our concurrent cause analysis based on the court's alternative causation analysis that each case of COVID was an equally effective concurrent cause of public reaction and government response. The analysis, and I'm sure my lords have got this, would then be that each manifestation of the disease would be an equally effective cause of the government response because all cases of the disease collectively, known and known unknown, together form the picture of a national outbreak or pandemic to which the government responded, and each case contributes to the causal chain by being part of that national outbreak or pandemic. You then, on insurers' analysis of the clause, have insured and uninsured concurrent causes. I know I've been through this in part, but I just want to demonstrate it by reference to the policy wording. With the uninsured cause, disease manifested outside the 25-mile radius, being an uninsured concurrent cause, but a concurrent cause which is not excluded. True it is on this analysis that any one case inside the relevant policy area was not individually a but-for cause of the government response, but the same is true of any individual case anywhere in the country. And of course, even if there had been a local outbreak, the same would have been confined within this 25-mile radius. The same could have been said of any individual case within the policy area. You could have said the same of any individual case. So it must be contemplating an outbreak. It wouldn't work otherwise. And the factual reality is found by the court on the agreed facts is, and not challenged by insurers, is that all cases cumulatively caused the government to act because together they created a picture of a national pandemic. That is not in dispute. One can describe them as interdependent causes or interlinked causes, but whatever label one applies, they were collectively the proximate cause of the government acting, and each one was therefore a proximate cause of the government action. If they were together, they were individually. Even if one looks at reported cases in each locality, once my lord saw the maps yesterday, those maps transformed the picture of what was happening in the country as the disease spread. And they did so cumulatively, collectively and cumulatively. And there is no rational legal basis for saying that one can extract one case from the list. But this is insurers' argument. They're saying one just because one can extract one case from the list without changing the government response, none of the cases was a cause of the government response, because that is effectively insurers' case. If there's a let's say, 1 mile area, and there's only one provable case in that area for a policyholder, maybe because they've only got one reported case, just taking an extreme example, they would say, oh, well, you could take that one case out and it doesn't make a difference. But you can say that for every single case. And that is not the answer to the causation question, because you end up with no cases, the government having acted, and no case of COVID being a cause of the government having acted when they reacted in fact before it. The proper way to look at it is to treat, we've said you can look at it as a jigsaw, just one way of trying to describe what's going on. That was criticised. Let's look at it as pins. Each case is a pin on the map. And if someone down in the civil service was sticking pins on the map, yes, of course I accept. If one pin had been dropped or missed out, it's not going to make much of a difference. But when you've got all of the pins together, it's each individual pin for each individual case, known or known unknown, that creates a picture of a national kingdom. And to overcome that argument, QBE has to go a step further. Not enough for them to say that this is a causal requirement that it be within the policy area. They have to go a step further and say not only was this clause addressing the local element of an outbreak by requiring some causal impact, but there was built into it a requirement that the local cases of the disease should be the sole proximate cause of the interruption or interference, as opposed to just being a proximate cause. And that introduction of exclusionary language is disavowed by Mr. Crane. Now, it could perhaps theoretically have been achieved or be achieved by reading in the words which is only before the word manifested. So shall be notified to them which is only manifested by any person whilst in the premises or within 25 miles. But that is self-evidently not only reading words into the clause, which Mr. Crane disavows, but is transforming it. Furthermore, we would submit, it's fundamentally inconsistent with the nature of the risk being insured, because a notifiable disease contemplates wide and unpredictable outbreaks, including the possibility of an epidemic, and one would expect such a restriction to be clearly expressed in this clause if it was intended. And the wide area is reflected in this particular policy by the 25-mile radius. Therefore, unless that radical construction of the clause is to be adopted, even if the clause is contemplating local outbreaks of the disease, contrary to the court's construction in our primary submission, it doesn't save QBE. And I've dealt with the only other escape they have, which is through but-for causation, which is their other way of reading an exclusion in. Because if you can't get an exclusion in the language only caused by, then the only other refuge insurers have, and it's perhaps Mr. Crane's only refuge because he's disavowed only, is through the use of the but-for test at this stage. So their last refuge to defeat the concurrent cause argument would have to be through the trends clause. And I think you've seen in this clause what the trends clause is. Just to show you the clause itself, just to remind you, 819. It has to be, that trends means adjustments will be made to figures as may be necessary to provide for the trend of the business in or variations in circumstances affecting the business. And you'll see that trend adjusted, that's a defined term, comes in, for example, I'm not saying these are the only places, but I think these are the primary places, 816, 2397, the definition of standard gross revenue, and 29, the definition of standard turnover. And that, you see, they've all got to be trend adjusted. That's page 816. And going back to 819, that makes sense of the phrase adjustments will be made to figures. And that supports, I submit, the submission that what I was saying to my lords yesterday about this being an arithmetic exercise here, an accounting exercise, not a revisiting of the causation question. And what the but-for test really wants to do is to introduce Wayne Tank by the back door through a clause that, as you can see, is just supposed to be the equivalent of an accounting tool. And I say Wayne Tank through the back door, as my lords know, that is the leading case which established or recorded the fact that if there are two concurrent causes of loss, one excluded and one insured, the exclusion trumps. If the non-insured clause is not excluded but just uninsured, then the insurance pays. But what they want to get the trends clause to do is to be a Wayne Tank for them, to introduce an exclusion of a concurrent cause, and that is impermissible. I should perhaps deal with one submission that was made, that has been made generally by insurers, and I can use it here, that the significance of the word within. And our submission about that is that there are limits to what that word can actually be doing. We say it's sufficient, gives sufficient weight and force to it to say that it's just saying that the case that is manifested has to be inside rather than outside the 25-mile radius, and that is sufficient for its purpose. But insurers require that to have two additional purposes. Firstly, to signify that it has the causes that are within the radius have to be causative, to confirm that link. And secondly, that they must be the only causes. And it's simply far too much weight for that word to bear. And my lords, that's all I wanted to say about QBE1, unless there were any questions my lords had on that policy. And I was then going to move to the two policies on which the court found against us, QBE 2 and 3, to explain why, in an otherwise impressive judgment, the court made an error in relation to these two policies. And I wanted to start with QBE 2, the relevant clause, tab 13, page 852. You'll see it starts with the word loss resulting from, the words that were missing in QBE1, which I said was probably just a mistake, from interruption or interference with the business in consequence of any of the following events. And I'll come back to those words in a moment. I just want to deal with the body of the clause. And you'll also see in H and I a reference to the word incident. And I'll come back to those words as well, because I want to start with the I've lost Lord Amlin's video. I just want to check that I still have audio. Probably not. I'll pause.
Yes. If you just wait for a moment, Mr. Edelman, I'll just see if I get any message from our engineer.
I hope it's not my
Yes.
It's overloading the system.
Yes, it looks as though Lord Amlin has left us. He's been disconnected for some reason and is going to have to try to join us again. And here he is.
Right. I was looking temporarily at my notes, but I may have been slightly slow in noticing that my Lord Amlin had gone, but I think I've just been saying some introductory words about this policy. So.
I've heard everything you said, Mr. Edelman,
Yes.
don't worry.
So what I want to focus on initially is the core words, any occurrence of a notifiable disease within a radius of 25 miles, and notifiable disease is defined, sorry, I forgot to write down the page number. It's defined on page 923. And it's 1867, and it merely requires, it says notifiable disease means illness sustained by any person resulting from. And it's, although you'll see the disease is defined in similar terms to QBE1, any human infectious contagious disease, outbreak of which stipulated should be notified, excluding AIDS. But this uses the word sustained by any person rather than manifested. And the court concluded, again, no appeal from these decisions as to what these terms mean, that sustained would be satisfied simply if a person was actually infected with the virus. So it's sufficient if someone was asymptomatic. Which again, we say is significant. And as to compared to what, if there was going to be some causative element to this, as to compared to what the policy could have required in terms of requiring a case to have been diagnosed and notified, a case within the radius to have been diagnosed and notified to the authorities. So all it requires is that someone within the 25-mile radius has become infected with the virus. And of course, as you've seen from the definition, it realistically recognises that these sorts of diseases will form outbreaks. It talks about an outbreak of which is to be notified. Actually, the clause, the regulations just refer to a doctor who diagnoses someone. You just then got to report it. You don't have to wait until you've got a certain number of cases to report it. You get one case, you report it, because these are dangerous diseases. And so, but the policy is acknowledging that what the risk it's contemplating here is an outbreak. And what QBE says, and quite accurately in its case at paragraph 17, if you want it, the reference, I don't need to look it up, it's bundle B, page 619. They refer to their policies as ensuring against the impact of, on the insured business, of a notifiable disease breaking out. The words a notifiable disease breaking out are their words. And that's what happens to notifiable diseases. If they're going to be a problem, if they're going to be a problem so as to interrupt or interfere with a business, it's because they will have broken out. A single case, that person will be carted off to some individual quarantine case. We all heard of cases, somebody coming back with some exotic location with a dangerous disease. They're detected, they're whisked off to quarantine. But these policies are addressing something more than that, which is why they use the word outbreak. It's something which will be of wider significance. So when we go to the word occurrence in C, what is that contemplating? We say it must be contemplating an outbreak comprising of however many cases occur in the policy area. It's an occurrence, of course, we say it's occurrence of a notifiable disease of which there are cases in the area, but the word occurrence must be contemplating an outbreak. It may be, and therefore contemplating there will be, yes, Mr. Woodland.
It doesn't really help to try and substitute the word outbreak for occurrence, does it? Because it can be one person, or it could be several. It's what seems to me pretty obvious on the wording of this clause, even if not the last, is that there has to be a causal connection between the occurrence within the area and the interruption. But you say that's satisfied if you don't apply a but-for test. Isn't it as simple as that?
Well, my lord, if you are looking at, if you treat, it depends how you read this clause, and the court read this one differently, but you'll see there's some similar language coming up. And if you read occurrence as being an outbreak, and it's an outbreak of a notifiable disease, what is the words within the radius? Are they saying an occurrence of a notifiable disease only within the radius, or only insofar as it's in the radius? Or when it's talking about, if the word occurrence is capable, because if you look up the word outbreak, and it talks about the occurrence of a disease, of an occurrence of a disease. So an outbreak is encompassed, let's say encompassed within the word occurrence, and certainly must be primarily what this clause is contemplating, because it's contemplating something some distance from the premises which interferes or interrupts with the business. So it must be contemplating something which is serious enough for the authorities and or the public to react to, even though it may be 24 miles away, so as to interrupt or interfere with the business. Now, theoretically, it can cover one case, but the word occurrence, we say, is more naturally to be understood as contemplating an outbreak. And an outbreak is naturally something that one would describe as an occurrence. It's not, may not be particular time, particular place. I'll come back to that in a moment when I come to the concept of an event. But one's applying this concept to a notifiable disease. And
I don't see at the moment where all this is going. I mean, the whole argument is that one case is enough. If it contributes to a national restriction, then it does cause, along with all the other cases, the interruption to the business.
Yeah,
and that's an argument I can understand.
Yes.
What I find much harder to understand is you're trying to rewrite C so that it means something other than an occurrence within 25 miles of the premises.
Well, it depends whether you read it as if it were to say an occurrence of an outbreak of a notifiable disease which is present within a 25-mile radius, 25 miles of the premises. That's how the court read it. Because they're looking at the concept. This is why you get back to the concept of what you're dealing with. You're dealing with a notifiable disease, which, if it's going to cause a problem,
well, it's actually not. It's not the outbreak which is covered. It's the occurrence of the notifiable disease, which is illness sustained by any person. So you have to have an illness sustained by a person within the 25 miles.
Yes.
And that has to be causative.
Well,
and on your case it is.
Yes, on our case it is. Yes, but we submit that on this particular language, that although it says illness sustained by any person, it's contemplating necessarily a disease outbreak, because that's what it's contemplating. And it's a question whether within a radius of 25 miles is something that qualifies the outbreak. So you're already dealing with that part of an outbreak, because what one has...
Well, I may not help, but I'm struggling at the moment to understand why you need to go through these contortions to try and make the clause read as though it's ensuring an outbreak, whether within or without, rather than an occurrence of a disease by a person within 25 miles, which is what it seems to say.
Well, I think that the critical point is whether that one reads that as an exclusionary requirement, and that may be as far as I need to go. If one doesn't read it as an exclusionary requirement, then that's sufficient for my purposes.
You're not saying, Mr. Edelman, are you, that if were only one case and it was within the 25-mile radius, that wouldn't be sufficient?
No.
Right. You're not saying there has to be an outbreak that extends beyond the radius?
No.
No.
No. But what I am submitting is that because this, I'm just trying to support the approach the court's adopted and other policies, that if the clause is, if what the risk, the nature of the risk that's being contemplated is an outbreak, and you're talking about something that could be 25 miles away, within the sphere of the scope of operation of the clause will be a distant, it will be an outbreak which will be of varying extent, but may well be within and without the radius. Now, the question is, it may be that you answer the answer in different ways. One answer may be, well, because that is the contemplation, and for whatever other legal reasons, one doesn't apply but for. But one other approach is to say, because that is what the clause contemplates, when one's looking at the radius requirements and the outbreak, one is looking at the radius requirement as being a qualifying rather than a causal requirement. And I've made that submission. I don't think I can take it any further. But the court took the view that it was only the inclusion of the word events and incident which introduced the causal requirement. And we don't accept that as being a distinction from other policies. But and it may be that I should just perhaps briefly make my submissions on event, just simply because it was something the court relied on as an additional factor, and we would say was wrong. We say that the following events is simply here used as a catch-all word to summarize what follows without giving them any particular characteristics. And so the starting point of treating event as being definitional is erroneous. I'll deal with this briefly as I can. Event may have an established meaning in the context of reinsurance aggregation clauses, in particular the JELC clauses, but what it means in each case must depend on the context in which it appears, and in particular what it's being applied to. And as I've submitted, multiple cases of a disease within the relevant policy area and outside would be regarded as an outbreak, and one can fairly describe an outbreak as an event. And there's no reason why, if the outbreak is also outside the relevant policy area, that should stop it being an event or create a separate event. It's all one outbreak.
Why can you not simply regard each occurrence as being an event?
Well, the only difficulty with that is if one then, it all depends if one's applying but for or not. If one's applying but for, you then end up with a situation that no one outbreak of the disease causes anything even locally, even if it's confined within the 25 miles. If you're not applying but for, then I don't have a problem.
Yeah.
These submissions are only made because of the but-for hurdle that's being put in front of me. If the but-for hurdle goes, and it is inappropriate as I've submitted, then none of this really matters, as long as my lords are with me on the concurrent cause. If my lords, I'm obviously not assuming anything, if my lords were to be with me on the concurrent cause case and with me on but-for, then none of this matters. It really doesn't matter how these are construed, unless they are construed in an exclusionary way, so as themselves by their very language to bring in a Wayne Tank sort of principle. so as to exclude the effect of concurrent cause, and that we would submit is going a stage too far. Yes. Lord Hutchins.
You say that the concurrent cause test is an answer, but the various cases that we've been given on concurrent cause, whether it's Reicher, Silver C, EME, COS, and this JJ, they are all cases where there are two concurrent effective causes. They're not cases where there is one cause which is an effective cause and another cause which isn't. Do you accept that?
Yes, obviously, because I accept that, because the proximate cause test is always looking for the dominant and effective cause, and you may, on analysis of the facts, find one that is, even though there are other competing causes. And in Wayne Tank itself, the court divided, the majority finding that one cause was the dominant cause, Lord Justice Cairns deciding that actually he thought it was more evenly balanced. But all of them deciding that the result was the same anyway, because even if they were evenly balanced, the competing cause which Lord Cairns decided was evenly balanced when the others didn't, was excluded anyway. So I quite accept that you don't get into concurrent cause if you've identified one dominant effective cause. But when you're looking at the disease outbreak, you can't identify one proximate cause. You can only identify all of the cases which go up to make the outbreak.
Yes, I see that point, but getting back to your earlier point, you said there wasn't but for, that the insurance law simply goes straight to proximate cause. But at the time when that was enacted in the Marine Insurance Act, the people would have said, as judges did say in Reicher and Boric, it is not sufficient that it's causa sine qua non. It has to be causa causans. So what proximate involved was a further requirement, namely that it wasn't too remote beyond the prior test of causa sine qua non.
Well, my lord, that's a question whether whether causation really is a mechanical exercise of stage 1, stage 2, where but for is always your first stop on your way to causation, or whether once you know your causation test, you then apply it to the facts, and you apply it to give effect to what it is you are applying it to.
But there you're relying on Lord Hoffman's commentary on the Fairchild Enclave, which is the exception rather than the norm.
Well, Lord, that part of his judgment wasn't actually to do with the enclave. It was really saying that the important point is to identify the appropriate causal test.
Yes.
He went on to then, in Fairchild to identify a novel causation test. But that doesn't affect the principle which he was setting out, which is that one identifies what the causal test is and then applies it to the facts. And that's what the High Court of Australia said, yes. And what the Court of Appeal adopted in Galoo, trying to move away from any mechanistic approach to assessing causation and assessing it on the facts, having regard to the purpose for which you are applying it.
Yes.
And that's why. And I just want to go back to those solicitors' cases, because that Travellers XYZ case, where there were hundreds of claims being made against the insured in respect of faulty breast implants. And of the hundreds, maybe about 30%, as a rough guess, I haven't done the maths off my head, a rough guess, let's say 30%, because it was there or thereabouts, and certainly less than 50%, were insured. And what the court did was to select sample cases for trial. And there were 4 sample cases, and costs were incurred defending those 4 sample cases, the issue being whether the implants were defective. Travellers were obliged, the insurer were obliged to indemnify the insured against the costs of defending insured claims. Mr. Keeley's application of the but-for test was insurance is all about indemnification of loss. And if you would have suffered the loss, even but for the insured contingency, you cannot recover. Now, that would mean that in that case, travellers should have been, on Mr. Keeley's analysis, been entitled to say, well, yes, of course, the insurance policy says that you are entitled to an indemnity against defence costs, but you've not suffered any loss by reason of those insured claims, because but for those insured claims, you would still have been paying the same costs to defend the uninsured claims. That is the mechanistic application of the but-for test, if you're assuming, as Mr. Keeley was trying to do, that insurance is all about identifying a loss that someone has sustained and applying a but-for test to that loss. Would you still have suffered the same loss for which you are claiming indemnity, but for that insured contingency, having to defend, in this case, the contingency is having to defend the insured claim. And it may be that in the realms of tort and contract, if someone suffered an injury and wanted to claim damages, and you were able to say to them, well, actually, you had a bad back anyway, and yes, my injury was a cause of the bad back, but your back would have been just as bad if I hadn't injured you. But for may be helpful. But in insurance, when you're insuring against contingencies, and there are 2 causes, one insured, one uninsured, both of which are capable of causing the same loss, and that loss is indivisible. In that case, you couldn't divide up the costs that were referable to the 4 sample cases. Then you have insurance. And it's because one's dealing with insurance. Perhaps there's the rationalisation.
Yes, well, I see where you're coming from in relation to the defence cost case, and you flagged it up earlier.
Yeah.
But my point was simply that if one looks at the cases to which the other cases to which we were referred, they were all cases where traditional but-for causation worked perfectly well on the facts in those insurance cases.
Well, I know Lord Briggs wants to say something, but can I just answer that point before I hand over to Lord Briggs? But the answer to that is no in Silversea, because but for the government warnings, there would still have been the terrorist attacks. My Lord remembers the point that I was making. Whilst the warnings, the insured warnings, were dependent, of course, on the attacks having occurred, the attacks came first.
That's the interlinked point rather than interdependent.
Yes. So the attacks were an independent concurrent cause. And the reason why the court allowed insurance, would have seen that as concurrent cause, is because this is not something wholly extraneous and independent which would have caused loss anyway. It's the sort of thing that is being contemplated by the risk that is being insured. And that's important. That's the interlinkage. It was explicit in that policy. It's explicit in this policy when you are covering notifiable diseases. It's the sort of thing you are insuring.
Thank you.
Lord Briggs.
Mr. Bailey, I was asking myself why the Travellers case didn't ring bells with me, and I realised when I looked at the paragraph of my judgment to which you referred us this morning, the reason is that it was common ground that you couldn't apportion costs between insured and uninsured claims.
Yeah.
What slightly troubles me, and I'm not even sure that common ground ever had to be explained in the case at all, is whether costs might be sui generis. I mean, I can quite see why you're using costs as an example, but I just wonder whether the origin of the principle that you can't apportion costs between insured and uninsured claims is really just a straightforward application of approximate cause, or whether it's sui generis and is just about cost, because cost is a separately insured item.
Well, that's why, my lord, when I referred to the authorities this morning, I made it plain that the submission I was up, the reason I was doing so was to answer the question that Mr. Keeley posed in order to justify his but-for test, being that one has to ask whether the insured has suffered loss. Would he have suffered the same loss but for whatever it is that's having to face the insured claims? So, yes, of course, defence costs are always subject to their own particular insuring clause, and they are special in that sense. But the general principle that Mr. Keeley was resorting to in order to introduce the but-for test is a principle that would apply just as much to that area, because you're still talking about, it would still be an action for damages for breach of the indemnity. If insurer refused to indemnify for defence costs, it's still the same remedy in damages. You failed to indemnify me against the loss that I have sustained through incurring a liability to my solicitors to pay costs. And it's the incurring of the liability, which is, it's not the payment of the solicitors. The loss is that I am now liable to pay my solicitors' costs. And so that is the loss that you've sustained. Your financial position is worse off than it was than you were before because of your liability. And Mr. Keeley is saying that is, you're claiming damages for breach of the indemnity. You have to show that you are worse off as a result. And you're not worse off if you would have incurred the costs anyway. You'd had to incur them anyway. You'd have been liable to the solicitors for the uninsured claims. That was the point that I was making. For that point, the nature of the insuring provision doesn't matter. And the fact that there have been issues about apportionment is because no insurer has ever had the temerity to argue that they shouldn't be liable at all in such a situation. They've only ever argued at most that they should be apportioned. Why should I pay all the costs where only 2 of the 4 sample claims were against me as the involved me as the insurer?
So I suppose if you're dealing with cover for business interruption in consequence of any occurrence of a notifiable disease within a given area, it would seem surprising if the parties intended that there would be recovery if there was a single occurrence, but no recovery if there was more than one occurrence, because a but-for test wouldn't then be satisfied, because it's in the nature of a notifiable disease that occurrences are liable to come in more than single instances.
And of course, the submission I made before, that if you're contemplating something up to 25 miles or even 1 mile away affecting your business, you are, although the policy only requires one case, it's necessarily contemplating that actually, if there's something to interrupt or interfere with your business, it's going to be an outbreak. And that's necessarily inherent in the peril, that it's contemplating at least that on the spectrum. Let me put it as low as I possibly could in my favour. That is on the spectrum of the contemplation of this clause. And once you're contemplating that, you must necessarily be contemplating that diseases spread as they do, and where the disease outbreak is and the way in which it spreads will depend on the particular characteristics of the disease, how quickly it spreads. And it can't have been intended that because even if the disease starts within the 25 miles, that just because it spreads outside and then attracts broader public authority action, let's say, that suddenly there is no cover, because the cases within the area have ceased then to be the proximate cause of the continuing interruption or interference. It just doesn't make sense to apply but for. And that's the interlinkage point that ties in with the Silversea approach, where you have the attacks which are, in that case, genuinely, the attacks are an independent cause. They're not interdependent. They were capable on their own of causing at least a major part of the loss of revenue. Well, yes, I think we've gone over 1 o'clock, but I'm happy to take.
I just wanted to follow up Lord Reid's question, because it seems to me that the point that Lord Reid's making there really is, if one took but for to its logical extreme, is within the area would defeat each other causally.
Yes, exactly.
Yes.
And if that can't be right, then there's no reason logically why cases outside the area should causally defeat the cases within the area, unless there were an exclusion in the policy.
Yeah.
I think that's Lord Reid's point. I was just spelling it out.
Yes, that's how I understood it, and was a submission that I was making before on the individual case.
And that's why the use of the more natural or workable construction of a disease clause, which only requires one occurrence or outbreak or whatever you want to call it within the area, must be a proviso rather than part of the definition of the risk.
Yes, that's why one then circles back and says, well, I'm looking at the language, but actually, if this is how it's supposed to work, how do we make sense of this construction? That's how the court's gone about it. That's why I start off with the nature of the risk before I introduce this. If these are all the consequences, what does all this tell you? If they didn't really intend a but for, what does it tell you about the true construction?
Well, as you can see, you've grabbed our attention, but if we can tear ourselves away, we'll adjourn now until 2 o'clock.